In the first term of the NDA government, Prime Minister Narendra Modi had said it was not the 2G scam or the coal scam, but the bank NPA scam, which was India's largest scam. In 2016, the Reserve Bank of India had come out with a circular, the intent being to detect fraud early on and to also bring in the investigative agencies early on. There was a mechanism that had been institutionalized, the idea being that you could detect frauds early and maybe it would not be left at the discretion of bank managers or senior general managers of banks or even the top management of banks. The question we are asking today is, in 2021, is it time to revisit that circular? How has the circular performed? Has it helped the banking landscape? And like most policies, is it time to revisit it? Joining us to talk about that is KV Karthik, the partner for forensic and financial advisory at Deloitte India, Prateek Seksaria, lawyer, S. Ravi, the managing partner at Ravi Ranjan & Co., chartered accountants and former chairman of the BSE. Gentlemen, thank you so much for joining us live on this Friday evening. Mr. Karthik, I'm going to come to you first. Just explain to our viewers first up, how is it that the framework has worked since 2016? I know someone who's involved in day-to-day dealing with forensics is it time to revisit the framework that had been institutionalized by the circular?
Sure. Let me take a step back here, Narendra. If I look at any fraud risk management framework, what does it mean is that the basic principle is to prevent frauds from happening in the first place. But you cannot prevent all frauds from happening. So what you need to have is systems and process and policies in place to detect them at the earliest and take immediate effective action on that. And if you look at the RBI circular that came in, that is what it precisely does, actually. And we also need to be cognizant of the fact that risks are inherent in the banking business, and frauds may happen and will keep on happening. But with the rise of the number of fraud incidences and not only the number of incidences, but also the value of the frauds, the organizations or banks and financial institutions need to put systems and processes in place to monitor this with this basic principle, which I just mentioned a minute back, in place. And what does the RBI circular says? One is that you need to have an early detection mechanism. That is where you're trying to prevent frauds from happening. And what also, if you look at prior to this 2016, if there is a delay in reporting, it also affects, because many of these frauds may not just be with individual banks, because it could be with consortium of banks. The moment a bank detects it can actually report to RBI and to other lenders through the RBI mechanism, so that others are also aware of these accounts. That's number one. So they look at it in three stages. One is a pre-sanction. They are asking them to actually enhance their pre-sanction mechanisms. In fact, not just in 2016, later on as well, RBI has come up with certain guidelines wherein they have looked at Maligram committee recommendation in terms of how you need to put various process in place, including, for example, market intelligence gathering, and how do you include that as part of whether it's a pre-sanction or sanctioning processes and as part of the due diligence mechanism that you do on an annual basis. So it has evolved, and I believe that the mechanism that they're put in place is showing effect. If you see the number of fraud that are getting reported, I mean, that probably is a sign of how it has helped in identifying the fraud cases, right?
Yes, in fact, let me build on that and go across to Mr. Ravi for discussing that. The number of fraud cases, Mr. Ravi, if you look at it, it went up to what? Significantly in FY20. The RBI's annual report, in fact, shows that how it went up, 1.8 trillion rupees and all of that. Is that because you started trying to detect fraud early on in 2016. But then on the flip side, Mr. Ravi, what we've also seen is since 2016 is, whether it's the PMC Bank, you saw what happened with Bank of Maharashtra and an arrest which the government said was an aberration. You, of course, then also had the Nirav Modi case, the Mehul Choksi case. So how should one see this circular?
So first of all, this 2016 circular started with early warning signals or alerts. Then they started red flagging. And there was enough time for the banks to sort of monitor and try to mitigate that risk of frauds. But once it got reported, then came the forensic audits. And what happened from the forensic audits came the account started getting classified as frauds. Now, here is a problem. There are these extreme cases of Mehul Choksi and all that, but there are other cases of where there are genuine borrowers who have dealt with the bank for 20, 30 years, have been servicing, but due to some economic reasons, they have perished. So we have to distinguish between genuine borrowers who failed because of some reason, some extraneous factors, and those who really committed fraud. And the definition of fraud itself is a very wide it's very wide, and that is where is the challenge. So I think 2016 circular should be revisited, should be relooked, and should be narrowed out to see that genuine borrowers do not suffer. And that is one thing that is very, very imperative from a systemic viewpoint. The second point is we have already got a SFIO which is there, which MCA has started, and which is a very good initiative. And they are looking at all the frauds, and they have got experts, and the capacities have been built in the last 3-4 years. They are already examining it. So I think referring is a different thing, but declaring the fraud is another thing. So I think it is very important that we get into the process. How we declare a company as a fraud, the process is very important in my view. And I feel because the amount of court cases that have come and the amount of appeals that the courts have given in favor of the borrowers actually shows that the process has not been followed in the truest fashion. That is my view. And because,
very important points there, and I would like to tell our viewers as well that this circular doesn't reflect always the current realities of business. The classification of fraud accounts are done without, people saying following natural justice principles, and the classification of fraud accounts is done without giving the borrowers a chance of being heard. With that, I'd like to go across to the lawyer in our panel today, Mr. Sexaria. When you look at all of this, the very fact that it is the bankers themselves who will be deciding and trying to do early detection without the borrowers giving it, any chance to explain if it's been a genuine business failure, whether it was because of inflation or any extraneous circumstances, lack of commodity, there can be multiple reasons for that. And the fact that they don't have to be heard, what has been the impact of that?
I think it's a classic case. Other than the early signs or the red flagging, so far as the classification of fraud is concerned, I would think this is like putting the cart before the horse, because the circular on one hand seeks to say that the classification has to be basis the provisions of the Indian Penal Code. But then at the end of the day, even before a court of competent jurisdiction has determined whether those issues which according to a bank or a forensic auditor might amount to a fraudulent conduct are genuinely fraud or no, the borrower is faced with a situation, not just that there is a complaint which is filed in sense of a criminal complaint before the CBI, but also that there are civil consequences in as much as his entire business is brought to a grinding halt. Neither can the borrower company then get any lending, nor can any of the other directors of the company be people who can get any lending. So that's really a classic case where the bank, who is a judge in its own cause, decides, and which otherwise under the circular is a mere allegation, because there is yet a determination finally to happen at the ends of a CBI complaint and through the process of a court. Now look at the anomaly. I think it would be a situation would be really prejudicial to a borrower that after an entire trial, the court comes to a conclusion that the allegations contained which form the basis of complaint by the bank were not correct and not justified, and there was no fraud element, and there was fraud not established because the burden of proof is very high. And by the time that conclusion comes, an entire business would have been destroyed because the lending would stop, the chance to enter into compromise would stop. So I think the circular certainly needs a revision.
Mr. Karthik, if I can now come to you, you at Deloitte are dealing with prominent Indian clients, you're dealing with prominent foreign clients, and you raised right at the beginning a very important question, which is that A, how do you define a fraud? And so just taking from your experience with working with clients from other countries as well, how can this framework be made more robust?
Sure. See, let me take you through the process of a forensic audit. For that, probably that will show some light. The way a forensic audit is conducted is it's an agreed upon procedure. You say that there are various things that needs to be looked into, and there the borrower is also expected to cooperate, and because he also needs to provide certain information. For us, we are third party, so we will work with the financial institution, in this case, let's say a bank, and work through that and identify certain instances which we call it as red flags in our process, and say this does not appear to be normal. Can you please explain it? So that is what the bankers usually go back to the client and ask for an explanation. So to some extent, there is a due process where is an interaction that happens. But having said that, at the end of the day, we are not lawyers. So we cannot sit in judgment and say that is that interpretation of a particular penal provision or under IPC, this is what is it, because that we are not competent to do. For us, we go by what the RBI circular says, and that's a very good definition, especially with RBI, which came in 2015 on the willful defaulter and what they classify as cases which could be called as diversion of fund and other aspects. We point out those anomalies, and then it is for the banks and financial institutions to take a call based on the comments received from the borrower on this report, whether they consider it as a fraud. They may consult with lawyers, I'm sure, and then they may file for an FIR with the enforcement agencies. So this is the actual process, a process where it happens. So number one is, if I look at even other countries, many of the countries may appoint a forensic auditor. The forensic audit is to look and find out if, when I say that the way it should have been processed, if I have given a loan, what is the bank looking at? The bank is looking at that once I have disbursed a fund, is the fund being utilized for the purpose for what I have disbursed? Is the company reporting its operations in a fair manner, and it is following the regulations in the country? These are the three things that they look at. And if you find that if the money for which it has been disbursed is probably not being used for the purpose for what it was disbursed, is something which we'll report as part of forensic audit. But having said that, that is for the bank's legal firm and the banks to decide whether they call it a diversion, and for the investigating agencies to fight it out in the court. So our forensic report will primarily point out these instances where we have seen that probably it's not been adhering to the guidelines or for the sanction conditions for what it has been provided, or the information that has been provided to the bank based on which they have taken certain decisions in terms of the amount of sanctioning that they have to done. There seems to be an anomaly in that information, is what will be pointed out in a forensic audit report primarily.
And once again, just to contextualize, when you had seen this harsh circular in 2016, there was a need for it. Remember those glaring headlines every second day as far as banking frauds actually went. And with that, Mr. Ravi, I'd like to come to you. Now, we've all talked about how you don't have, proper standards for forensic audit that has been laid out. but also the fact that it is decided unilaterally by bankers, giving no hearing to the borrowers, and the complaint goes directly to the CBI. Do you think maybe it's time to have a specialized agency? We all know about how overworked the CBI is. We've already anyway talked about the under trials, and many of them might be in prison, and the rates that we actually see. So could that help if we actually have a specialized agency and maybe even a specialized court?
So first, about the forensic standard, let me tell you, Institute has come out with 30 odd standards, of which 17 have been notified or 13 have been notified, and of which is not compulsory nor mandatory. It is just to be notified for implementation. So every chartered accountant, every forensic auditor can follow that and use that standard. It is already available everywhere, and I think the new audits that are coming in, that forensic standards will be utilized. That is the point that I want to make. The second point is about centralized agency. SFIO, if you see, under the Ministry of Corporate Affairs, has enhanced its capabilities in the last few years. And if you see, there have been a lot of cases that have been referred to SFIO, which is a specialized body, which was non-existent prior to 2013, has become very active, and it is a place where all the frauds are examined there, and all the major companies where frauds have been reported are being examined there. So SFIO is a centralized body at this point of time, though we may have CBI and other agencies, but this SFIO is a very specialized agency that has been built the last 3-4 years. The other factor that I want to also bring in is the multiplicity of regulators. SEBI is also conducting forensic audit. There is an audit conducted by ED, there EOW. So everybody has a forensic audit which is conducted in the same company. Maybe they use each other's report also. That's another fact which is concerning to most of the people. The third point that I want to bring about the forensic audit also. We go beyond the law. Say, for example, probable connected company. So we have 3 definitions already: related party transaction, associate company, and we have subsidiary company. But we go beyond that and say probable connected company. So this is another thing. The forensic auditor there must be standards which bring in uniformity. And that is important, because what is a probable connected party? I think we are not here nor there. So I think this is where the whole system needs to come and bring in uniformity. Otherwise, what will happen is all these cases, as Mr. Prakash stated, it will go to the courts and get defeated. So I think there needs to be uniformity, which has to be brought in, standardization of reporting to a great extent, and we should have a centralized agency, as you suggested, as you said, and already taken steps by Government of India. I think we should have a centralized agency which looks into this, which has specialized people, which can interact with the forensic auditors, who can understand their language, their concerns, and who can go along with the forensic auditors and help the banks in taking this whole movement forward, as they say.
Right. Mr. Sarah, so while we wait for the uniformity that Mr. Ravi was talking about, the need for specialized agencies, for which I think all of you unanimously agree about, Mr. Sarah, another problem, and this is what people have been talking about. The bankers unilaterally decide, right, without giving the borrowers even a chance, whether it's to do with business failure or to be heard. Now, what happens in those instances, and I've all read about those instances, where you also have employees, management of the banks, complicit with the borrowers. Now, they're not going to be sitting and saying, I'm guilty. Justice should also be done and be perceived to be done, right? So how can that part be corrected? Should it, for example, all these cases be referred to a third party? Should a third party be carrying out an audit?
You're absolutely right, because this is the fundamental problem with this entire RBI circular. As both my friends on the show told, that in 2021, we still are. Yes. So I don't know if you heard me. I said this is the fundamental flaw with the circular, according to me, that while in 2021, we are still in the process of releasing or notifying the standards for forensic audit. The RBI circular's classification proceeds only on a sole premise that you have to look at the provisions of the Indian Penal Code. Now, whether it is an auditing firm who is given the task of looking into the accounts with the perspective of finding out something, whether it is wrong, and of course, it may report whether it thinks in its subjective opinion whether the borrower or people who are connected with the borrower or people connected with the bank have done something wrong. It is finally left to the decision of the bank or the consortium of banks. And the funny part remains is that even when it comes to a consortium of banks, it just needs a 60% majority. So even if there are people who are dissenting, and that's 60% in value, so you have a situation where one particular bank who has 60% lending in value and may have other 10 other bankers who may dissent and not subscribe to the forensic auditor's view. You have a situation where the complaint is filed and the person is already classified that the accounts are fraudulent. And then, as I said earlier, that the bank sits as a judge in its own cause and there is nobody to look into unless and until it goes to trial before the court of competent jurisdiction whether there was somebody in fact complicit at the end of the bank themselves.
With that, thank you so much, gentlemen, for joining us this Friday evening.
Thank you.
Thank you. Thank you.